Welcome to this second Obit3r short. I'm going to be asking the question, what is justice? Is it about fair outcomes? Is it about reliable, standardised ways of resolving disputes? Is it about the way that the state's justice system actually works? Is it about equal application to every person? Is it about the sanctions and the punishments and the remedies actually being fair in themselves? Is it about a framework which allows society and economies to function properly? Or is it about fundamental human rights? The answer is it depends who you ask. People's conceptions of justice is a bit like a recipe. For each of us it may contain different proportions of different ingredients, baked or even half-baked, and then shared out on the basis of personal taste. It's possible to see law, morality and justice as overlapping but distinct concepts. Most crimes are not prosecuted. Most civil legal issues are not litigated. The justice system often serves merely as a backstop. The rules of human interaction are governed often by social norms and morality and the law, three independent moving parts. Out of the opening questions, we can boil them down largely to two central theoretical questions. The first is law the regulation of morality? At the extreme end of criminal law, murder clearly contravenes traditional moral values. However, parking offences are illegal, but they're not necessarily immoral. Conversely, a cheating spouse might suffer moral criticism, but clearly no legal action. Law which permits and regulates stem cell research is found to be morally objectionable to some. Law is no longer a simple medieval means to remedy mischiefs. It's become increasingly technical in nature and sets the rules by which frameworks operate. For instance, the procedure for winding up a company or administering a trust. A missing signature might be a serious legal issue, but it's far from engaging moral questions. The Wolfenden Report in 1957 led to the decriminalisation of homosexuality. The central argument was that some moral questions should not be regulated by law. HLA Hart believed that morality is not constant, and it's well served by social pressure. Lord Devlin, on the other hand, was strongly opposed to this view and argued that without common morality being embedded in law, society would collapse. In conclusion, law and morality overlap somewhat, but they are not conceptually identical. The second theoretical question: is justice fair process or fair outcome? In democracies, there's usually scope for almost any law to be reformed or repealed, and on the basis of democratic will, expressed through the relationship between the citizen and the state. Law created through democratic process is not necessarily just or moral. Justice can be described as the actual substantive content of the law and the way that those laws are formally applied. The role of the judiciary to merely interpret rules is questionable. Dworkin recognised that the judiciary apply their own political morality in legal process rather than baldly declaring the law. And this underscores the separation of powers between lawmakers and the courts. A just outcome in a legal case cannot be seen in isolation. It's the product of the integrity of the legal process. So a conviction in a criminal case is not justifiable if the process was unscrupulous. The rule of law is a concept which relates to the standard of the legal process. Lord Bingham argued that this contains principles such as equal application of the law, access to justice, clarity of the law, fair process, limiting the arbitrary power of the state, and the protection of basic human rights. The rule of law in this form could be argued as the gold standard, particularly in providing a check and balance to be used in the judicial toolkit against democratic power which oppresses minorities or fails to adhere to reasonable standards.